Good afternoon. My name is Cheryl Wilke. I am partners with Rob Sickles in the firm of Hinshaw Culbertson, and I was asked to come to present to you information regarding labor and employment laws. In the past, it was your choice as an employer as to whether or not you wanted to conduct a background check. Background checks, in my definition, and for the purpose of this presentation, background checks include both criminal background checks and credit checks, okay? Determine if someone's had 19 bankruptcies and has been arrested for being a convicted pedophile. You want to know that sometimes. In the past, you had pretty much carte blanche authority. Last month, or 2 months ago now, in April of 2012, the EEOC issued a new regulation requiring that background checks be a quote-unquote requirement and necessary for the position, and that background checks not unfairly target minorities. Here's where this came up. They were doing, certain employers, and in this case, I want to say it was Marriott Hotels, was doing full-level blanket background checks on everybody. Because of the number of minorities in this particular community who had been convicted of felonies, they were not being given, allegedly, the same employment opportunities. Well, my concern, of course, of this is, well, that's not really a minority issue as much as it is, I don't care, I'm guessing that as employers, y'all really do not care if they're blue, green, purple. You do not want convicted felons working for you. The EEOC, though, and you guys know that this is a big hot button issue for the administration, is EEOC and Fair Labor Standards and employment laws in general. So we have to be careful about this. You have to make sure that your background checks don't unfairly target minorities. So let's say that you have that one of your dealerships or that all of your dealerships have car wash stations. And let's say that the majority of the people who work at your car wash stations are minorities. Well, those people aren't really touching any money, and even though they may have to move cars a little bit, most of the time, since they're not in a fiduciary responsibility for you, they don't have a fiduciary position for you, do you really need to do a background check? And what they're saying is, what the EEOC is saying is, basically, and putting it in terms of car dealers, here are the people that you are allowed to do criminal background checks all the time without question. If they touch keys, cash, or checks, you can do a background check every day, all the time. If they wash cars, if they wash windows, if they take care of the plants around your facility, probably not. The EEOC is really cracking down on that. They're saying that it's a discriminatory practice, but very clear, keys, cash, and checks. If they're moving cars, driving customer cars, driving your cars, moving cars back and forth to auction, whatever it may be, if they touch cash at any time or checks, you are entitled to do background checks. Crystal clear, no problems there. Criminal background checks are still acceptable for the, yes, sir?
So that's everybody in the dealership?
Pretty much, except, and here's an example. Most of your dealerships don't have this, but the little 19-year-old girl who sits out front and greets customers, nah. Your receptionists, sometimes your service techs, if they don't actually move the cars. You know, it's really, it gets to be fuzzy. If moving cars is not a key part, if having keys is not a key part of what they do for you, such as service techs, you may want to think about whether or not you want to do background checks. Now, here's my theory about that. If your techs are going to be in and out of other people's cars, I really do believe that's enough. Probably got to think about it a little bit, but overall I believe that's enough, because that's close, pretty close. Actually, it used to be, it was recommended that you check everybody. Now it's actually gone the opposite direction after April of 2012. Now they're saying you should background check those people in these job categories. Salespeople, accountants, controllers, finance people, anybody who has access to cash, check, or keys. Now, what you can't do is you can't say, I'm only going to do background checks for the women who are in this group, or I'm only going to do background checks for the Hispanics that are in this group. That's what you cannot do, but you already know that. That's not what you're going to do anyway. But you can break it out by job classification. And this is really, I hesitate to say, I had lunch with these lovely, lovely gentlemen today, and they were saying that they think the laws should be different, and I agree, and I am very concerned. Now keep in mind, this is right now just an EEOC rule. It is not a statute, but it is a guideline. Generally what happens in this administration is that EEOC rules become regulations, the regulations become statutes. So this is what you have to look forward to. Pre-employment credit reports, including reports of prior bankruptcies, can still be used for hiring purposes except in these 3 states, New York, Connecticut, and Vermont. Those states comprise what we call the Second Circuit Court of Appeals. No, you cannot fail to hire somebody in those 3 states because of what shows up on a credit check. It's completely opposite of what's in every state. I had the case in the 11th Circuit, which is Florida, Georgia, Alabama, down in the South, and it was a case of first impression. It went up to the 11th Circuit. I tried the case out of the back of my truck in Ocala, Florida. If any of you have ever been to Ocala, Florida, you know exactly what I'm talking about. It's basically where cases go to die. But I tried this case up there, and the issue was whether or not we could refuse to hire an assistant manager at a dealership because he had filed for bankruptcy, and after his bankruptcy, he had missed payments. And our position is we didn't have to hire him because if he can't control his own money, how come we're going to let him control ours? He appealed that. We tried the case. Jury was out for 35 minutes. I won that case. They took it up on appeal. We won at the 11th Circuit. So now every circuit in the United States except the second allows you to base your hiring decisions on someone's credit background. You can still do that. I think that that's actually, to some degree, more important in some aspects than a criminal background. And the reason that I say that is, especially you guys, keys, credit, checks, cash, you guys have it all. And if someone is in financial straits, it's pretty tempting to have access to those items. Yes, sir?
Well, my concern is that most people should have secure documents or privileged documents. Why would you want somebody that's a felon not to?
Absolutely. Absolutely. Now, they don't distinguish confidential financial information as a reason under the rule to do a background check, but in my mind, that goes with the cash part and the check part, because basically what you're doing is you're using that information to make financial decisions, to control financial decisions, and I believe that that is sufficient, even though that's not exactly what the rule says, but I think your point is well taken. Yes, sir? Okay. Here's the deal with drug tests. How many of you are in the state of California? Okay. Besides you, because you're different. Okay. Besides you, you have the right to do drug testing for you have the right to do 4 different kinds of drug testing. Here's the problem. If you choose to do one, you have to do all of them. You can do pre-employment. You can do post-accident. You can do reasonable suspicion. And you can do random. Here's the problem. You can't say, I'm only going to do pre-employment drug testing. Okay? If you do it, the law and the regulations require you do them all. Sir, from California, they do not allow random drug tests in the state of California. You only get to do 3. They don't like you. No, state of California does not allow random drug tests. Yes, sir.
About 3 frames ago, I thought it said mandatory credit checks and employment checks, background checks. Did I read that correctly?
It says, if this is it, there's no such thing as a mandatory credit check or a background check. You can do whatever you want. If you're going to do it, you have to follow these rules, okay? No, there is no such thing. You don't have to credit check anybody. You don't have to background check. You don't have to drug test. How involved do you want to be in the pre-employment process with your employees? I think you want to be very involved. These people control your keys. They control your cash. They control your customers. How much more do you need? So now I realize that there's financial issues that go with this. Drug testing is getting to be more expensive. If you want the benefit, most states allow you to have a deduction off your workers' compensation premiums if you do drug testing. Sometimes it's as much as 15%, so it can be pretty substantial. If you tell them that you're a drug-free workplace and you have a drug testing program, they will take 15%, up to 15% off your premiums. So there are sometimes you can get that money back. The cost of testing, you can get that money back from the premium, from a reduction in premium. You can check with your insurance agent or your third-party administrator, whatever you use for workers' compensation. Talking about federal and state minimum wages, one of the handouts that you have, I have given you, I believe, from 2008 to the present, all of the minimum wages for different states. Everybody always says, well, isn't the minimum wage $7.25 per hour? Sure, in some states. The federal minimum wage is applicable to federal employees. It's guidance for other states. States are allowed to create different minimum wages. You will see that Minnesota has a minimum wage that's less than the federal minimum wage. You will see most states are equal. Some states are substantially higher. For example, Vermont, $8.46 per hour. Texas is right at the minimum, and Minnesota is only $6.15. But listen to how Minnesota breaks this down. They say that if you have $625,000 or more in revenue, the minimum wage is $6.15. If you have less, then it's only $5.25. So they actually break it down by the revenue of the employer. Only state that does that. I think that's really strange. I don't even know how you audit something like that. But that is, anybody else from Minnesota? I know a couple of these guys talked about Minnesota. Why they do that is complete. What are you guys doing out there? I don't know. Maybe it's cold and you don't have a lot to do in the wintertime. I don't know. Yeah, I guess. Here's the deal with you guys, and just to reiterate this. Your commission salespeople, okay, I'm going to go through this. Everybody always says, I don't have to pay my commission salespeople overtime. You are correct. You are still correct. So far, they haven't touched that. That's been around for a long time. You still have to ensure that they are obtaining minimum wage for the hours worked. You are not exempt from the minimum wage. You are exempt from overtime. And I cannot tell you how many dealers, I would say that probably 15 to 20% of the Fair Labor Standards Act cases I get are dealers who legitimately believe that they're exempted from both. You are not. So you have a salesperson who works 60 hours a week. How do you calculate their draw? Multiply it by the minimum wage. So then you know for sure that no matter if they do work that full 60 hours, they are always getting paid at least minimum wage. So make their draw approximate, take the hours worked, multiply it, add a couple for a cushion, multiply it by the minimum wage in your state, and that should be your draw. That is the only way to be crystal clear. Techs are the same way. If you're service techs, if you're doing it on the standard tech rate, an hour tech rate, then you have to make sure that they are also getting a minimum wage. Where does this come into play? If any of you have the oil change stands, sometimes they get quiet and your employees sit there for 2 or 3 hours without something to do, and then something comes in and then they get a couple hours of work time. You have to make sure that they are still getting minimum wage for all the hours worked. Okay. Most states and some counties and municipalities have their own discrimination laws and administrative policies. This is, especially for this poor gentleman in California, probably one of the scariest things that's out there, because I know from having the privilege of working for many of you for many years that you try really hard. And car dealers in particular want a diverse workforce. Why? Because your customer base is diverse. There's absolutely no reason not to explore a diverse workforce. That's what you want. Brings in more customers, you get people who speak different languages. It's a great thing. So you try to do the right thing more than any of my other employers. You guys are the best because you understand the nature of your customer base. Okay? So even if you get the federal stuff down, you still got to deal with the state stuff. And the state stuff can be even more scary. For example, some of them extend the time for filing. Most of you guys know that once you fire somebody or if they leave, they've got 300 days under the EEOC to file a charge. Some states extend that, give them longer. So you think you're out of the woods and you get this state claim and you're saying, what is this? Can provide different remedies. Generally, the state laws and the state requirements are much more favorable to employees than the EEOC. Now, for those of you who've been through the EEOC process, you're saying, Cheryl, you have no idea what you're talking about. These EEOC people are completely employee-oriented. Well, welcome to the real world. If you ever have a chance to sit in front of the Florida Human Relations Commission, I can assure you that those folks are almost completely employee-driven. The FIA claims out in California, even worse. Here are some examples, and I've used the state of Florida just as an example because remember, Florida's a right-to-work state. So you're thinking, okay, this is as far as we can get to being an employer-friendly area. We're a right-to-work state, no unions. We have it's kind of the Wild West out there as far as employment laws are concerned. Under the EEOC, an employee has 300 days to file a charge, but in the state, they get 360. They get almost a whole year. Okay, you can, but rarely proceeds with independent charges after the determination. The EEOC does not take its own cases. They go ahead and they say, okay, you have a right to sue, or there's probable cause, or there's not, but they don't get involved. They don't touch anything. States, they love to pick up the mission. They love to get the publicity. They love to talk about how they're serving their public. It's a big political issue with the states. Mediation is optional with the EEOC. If you agree to go to EEOC mediation after a charge is filed because you want to sit down, talk it out, make sure there's not a misunderstanding, maybe settle the case, maybe agree to give a job back, whatever it is, it's optional. It's up to you. If one party doesn't want to go, nobody goes. States can tell you have to show up. Not only do you have to show up, but you have to show up in good faith and bring stuff. Remedy is to proceed to federal court. So once you get through the EEOC process, if you're not happy, if the other side's not happy, you go to federal court, okay? Remedy is to proceed to state court. Well, what's the difference, Cheryl? You're going to end up in court anyway. You got to hire somebody like me, somebody like Rob to go defend you. Why would you want to do this? Here is the difference, folks. Your juries in federal court, they're comprised of registered voters. Your juries in state court are comprised of anybody with a driver's license. Anybody with a driver's license. Keep in mind that many states, you don't even need to be able to prove that you're a citizen or legally able to be employed to get a driver's license. Thank you, state of California. And Arizona, and the great state that we're sitting in right now, Nevada. You don't even have to be able to show that you're here legally to get a driver's license. Do you have any idea what your jury is going to look like in a state court case? It is all these people who, unfortunately, life has not treated all that well, and they're going to take it out on you because you're the big bad employer. Now, who's in federal court? Registered voters, business owners. These are the people you want on your jury. So if you leave with nothing else today, and you have a good employment lawyer, make sure that they always get you into federal court any way possible. There's lots of ways to get to federal court. Go to federal court. Do not be scared of the concept. You are much better off as an employer in federal court than you are in state court, especially in big bad states. Illinois, Indiana, any I state or square state, you are definitely better in federal court. I states are the worst. Those I state juries, they'll get you every time. Indiana, Iowa, Illinois, they're terrible. They're very, very tough on employers. Minimum employee requirements for workers' compensation. I get this question all the time because a lot of times you've got commissioned salespeople, you've got people who work part-time, you've got some independent people come in and clean cars, sometimes you've got people who do some body work on the side. Who needs to be covered? Who fits into that category for workers' compensation? Handout number 2 is a list of states and the minimum requirements for each for determining whether or not you have to have workers' compensation. I was sitting at a lovely table with this nice gentleman and this gentleman, and they said, well, you should come up with a compendium. Here's my compendium. I did 50 states. I went through the laws of 50 states to bring this to you so that you know, no matter what state you are, what the requirements are for having employees and having workers' compensation. Now, here is the best piece of advice that I can give you. It doesn't matter what you call them. You can call them independent contractors, you can call them my dog Fred, you can call them whatever you would like. The requirements for coverage of workers' compensation are not determined by their title. Yes, sir?
What if they're not a W-2 employee?
See, sometimes it doesn't matter. In states like California and Florida and Illinois, it makes no difference how you pay them. If they are, it's followed by the control test. Can they work for other people? Do they have their own license? Do they have their own business? Do they have their own LLC? Do they pay their own taxes to their own business? Do they use their own equipment? It's all based on these multitude of factors that determine control, not how you pay them or what you call them. Because I love it when I get these employers who say, nope, I don't have any employees. And I said, well, who are all those people on that roof with your shirts on? Those are independent contractors. I said, how do you pay them? I write them a check. Do you take taxes out? Nope, they're independent contractors. Well, can they work for other people? Well, no, they work for me. Do they use their own tools? Well, one of them has a hammer. Well, what about all that other roofing stuff up there? No, that's mine. Do they have their own vehicles? Nope, my vehicle. Really? Do they have any special skills? Nope, they're laborers. Never, 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 never are they going to be considered independent contractors. If they're not independent contractors, they go into the calculation to determine if you have to have comp. It sounds more complicated than it really is. Let's look at some states. Georgia and Michigan require 3 or more employees for coverage. California, all employers, public and private, regardless of the number of employees. They just don't care. Okay. Mississippi, 5. Mississippi's the highest. They let you get away with having 4 people employed before you have to have comp. South Carolina, 4. Wisconsin has a strange law about farmers being excluded, blah, blah, blah. I think that's a Midwestern thing. All right. The big questions. We talked about comp and how many employees you have to have. You say, okay, I have to have comp because I have 16 employees. Are they still covered by the Family Medical Leave Act? Do I have to give them the 90 days off if they're hurt or sick? And do I have to bring them back? And am I covered by the Americans with Disabilities Act? Those 3 things are kind of what we call the Bermuda Triangle: work comp, ADA, FMLA. Everybody hates it. That's the way it works. The Americans with Disabilities Act, which is now called the Americans with Disabilities Amendment Act law, says that you have to have 15 or more employees employed for 20 weeks or more prior to the request for application. Note, it does not require the employee to be employed for any period of time. It applies to applicants as well as active employees. Well, Cheryl, how is that possible? How can a law apply to someone who's applying for a job? Here's how it works. A nice woman comes in and applies for the job in your office as a receptionist. You have a receptionist position open, she comes in. She happens to be Hispanic, she happens to be in a wheelchair. She comes in, she has a beautiful resume, she's worked as a receptionist at other car dealers, she actually understands finance, she's bilingual, that works in your territory, it's perfect. However, where you would like your receptionist to sit is in this console area with a little door in the back and 3 steps. Can't hire you. This is where you're supposed to be. No! No! The Americans with Disabilities Act says you have to provide accommodations to applicants if they're otherwise qualified, and if those accommodations are reasonable. So is it reasonable to take those 3 steps and put a ramp so she can wheel up there? Probably. So it is not, well, they've only been here 3 days and now they want an accommodation, they haven't been here long enough. No! From the time that an applicant walks in your door, if you have 16 or more employees and otherwise meet the requirements, you are covered by the Americans with Disabilities Act, and so are they. I get this all the time. This is becoming one of the biggest areas now of these claims. Family Medical Leave Act, that's different. That's that law that you guys have heard about where you have to give them 3 months off, non-paid, and bring them back and all that. Well, when does that apply? Private sector employers, which is you guys, with 50 or more employees during a 20-week period. So most of you, I'm guessing, can say, I don't have to worry about this. That's good. I'm hoping that many of you don't have 50 or more employees. If you're big enough and bad enough to, good for you, but the FMLA does apply. So does the ADA. And with you guys with 15 or more employees, the ADA applies to, you know what, I knew I kept you around for a reason, Rob, honestly. Thank you very much. The employee must be employed for 12 months. This is not consecutive months. So if you have a particular seasonal kind of workforce where they work 6 months on, 6 months off, 9 months on, 3 months off, whatever it is, they just have to be employed within a 5-year period for 12 months to qualify. They have to have worked 1,250 hours during the 12 months preceding the request. This is where you're usually excluded with your part-time workers. It usually does not apply to your part-time workers. Okay. Yes, sir.
If we have 50 or less employees, the 1,250 during 12 months doesn't apply?
Nope. You have to do the employees first.
So employees first, then you have 10.
Right. If you don't meet the minimum requirements for employees, you can stop there. You're done. Doesn't apply. None of the other stuff matters. You can't backdoor through the ADA or the FMLA, thank goodness. So let's say that you've got 22 employees and you're in the state of Georgia. You're covered by comp, you're covered by the ADA, you are not covered by FMLA. Let's say you're in the state of California and you have 4 employees, okay? You're still covered by comp. And you're still covered by the ADA in California because they have a 0 requirement for the number of employees in the state of California. bad, tough place. I mean, I love it out there because it's just job security for me. But it is, California is tough. California is the toughest. That's kind of the benchmark. Yes, sir.
I'm from Minnesota, just recently hired an employee as a salesperson who has been in the state of Minnesota for a while. Saturday afternoon before I left, I went and checked my mail. I got a piece of mail from California, literally a half-inch thick, talking about child support. That this person evidently has been paid in California.
Yeah.
How much of that do I think I required to fill out?
Well, okay, let me go ahead and I'll restate the question. I will. Okay, you've hired an employee. You're in the state of Minnesota. Everything's roses and sunshine. The employee is good. He's a Minnesota resident. Everything looks great. Commissioned salesperson, you're good to go. A couple weeks after you hire him, you get this beautiful, thick packet of information from the Department of Family Services of the beautiful state of California saying he owes his ex-significant other $62,000 in child support, and you must fill out all this stuff and deduct X and send it to that, blah, 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 blah. How much of that you have to do? Okay, now we're going to do the Cheryl lawyer, and then we're going to do the Cheryl business answer. The Cheryl lawyer is you have to fill it all out and send it back. The Cheryl business person is it'll take them a year to catch up to you. I mean, I hate to say this, but they send that stuff out. Listen, I don't like I'm a stickler for kids and animals. So if it's the right thing to do, fill it out, deduct it, send the money. I'd rather see it go to the kids. If they're entitled to it, they should have it. However, the state of California does not have jurisdiction to file suit for collection against you. They can go through the state of Minnesota and do a writ. That'll take at least a year, and then it's a writ of garnishment, and then you'll pay it to the registry in the state of Minnesota, and then they'll forward it to California. So the reality is you guys have to decide what's in your best interest and what you really have the business time to do. Should you fill it out and send it back? Yeah, you probably should. But the reality of it is the state of California does not have jurisdiction over you. They can't tell you what to do. They can go ahead and petition the state of Minnesota to tell you what to do, but that takes quite a while. But you didn't hear any of that. Okay. Yes, sir? I know, I heard that. But they told me that they got a new camera and it's going to make me look like Sandra Bullock, so I was pretty excited about that. So even with the FMLA, so let's say you've got the 16 or more employees and you think, okay, I know what the law is, I'm going to play by the rules, if I need to give people time off, I'll do it, I'll bring them back, et cetera. Well, even if you try to do that, you have to know what your state law is. Because FMLA allows for 12 weeks of unpaid leave for a serious health condition that makes the employee unable to perform the functions of his or her job. It includes the serious health conditions of some family members, spouses and children, the birth or adoption of a child, and some military situations. Here's the big one now. Remember I said there was the Amendments Act? It was amended in January of 2010 because of the wars in Iraq and Afghanistan. And it says that if you employ, let's say, a woman whose son is coming back from a tour of duty in Iraq, she can take up to 12 weeks off to spend time with him. If you have a man whose wife is being deployed, hopefully that won't happen anymore, but if there's still deployments going on to a military zone, he's entitled to up to 12 weeks off to make sure that all their affairs are in order and spend time with her before she leaves. So it has been broadened. Even though there's no serious health condition, they've gone ahead and put a military benefit component into it. California, notwithstanding what the federal law says about the birth or adoption of a child, in the state of California, they get 16 weeks, 4 whole months off. So I have 12 associates in the state of California, 8 of them are women, and they all decided to have their babies at the same time. So I got to spend a lot of time out there because I had a lot of people off, and 4 months is a long time when you do litigation. But that's the law, and that's what you do. All right. Questions about FMLA, ADA, EEOC, Fair Labor Standards? I want to get all those because I'm going to go into this other stuff is good, but it's not as important, and I want to make sure I answer all your questions about those, what I call the big 3. FMLA, ADA, discrimination, work comp, anything? Okay. Some states, and I know that you guys deal with more, Rob and I were talking with a client of ours at one point, and my client who owns a whole bunch of dealerships, and he said, You know that there are 61,000 regulations that control auto dealers. I said, wow, that's a lot. Well, here's the problem. You all do such a good job of trying to make sure that you comply with those 61,000 regulations that sometimes some of the state stuff gets lost in the shuffle. For example, Florida requires occupational licenses for everybody in the state who's working with cash or keys or anything of that nature. So sometimes, even if you've done everything else that you're supposed to do, you still have to pay $15 a year to your county in the state of Florida to ensure that you have occupational licenses. You guys know the rules regarding DOT license, Department of Transportation. You have to be 18 years old to have a CDL. I will tell you that there is some discussion about raising that to 20. I think that's going to be a little interesting, but it's supposed to be for safety reasons, I don't know. You have to be 21 years old to operate certain equipment, which includes working in a machine shop. So if you guys have more than just a regular tech center, if you actually do parts, machinery, stuff like that, the people who work there must be 18 years of age or older. You have to be 21 years old to serve alcohol. I don't think you're doing that at your dealerships, but I'm just throwing that in there for examples. OSHA certifications for mechanics, equipment, and operators require minimum wages too. Fortunately, you're not OSHA's biggest problem. They got other bigger problems. But I will tell you that to operate anything with hydraulics, they must be 18 years of age. There's certain OSHA requirements. To operate forklifts, you have to be 18. There's certain requirements for things like slicers and things like that that are in restaurants. But just so that you know, notwithstanding everything else you guys have to do, which I think is pretty serious, there are also things that you have to remember from the state level as far as your licensing and certain requirements for safety. This is, is that supposed to be an E? W-I-L-K-E. It's amazing. I can do everything and spell my own name right. But you guys, it's right on the bottom there. This is me and where I am and how to reach me. Here is the deal that I have with the wonderful people at NIADA. I will answer all of your questions for free. So if you have questions, you can call me, and if I don't have to look it up and I don't have to write anything down and I can answer your question, I do that for free. That's part of the service that I provide to them. Oh, I like, yeah, you in the back. I do not, but if you send me an email or call me with the state that you're in, I can let you know exactly what your requirements are. I'm sorry? Which? It is. I'll help you with the occupational licenses in Florida because they're county specific and they are becoming a much bigger deal because they are a revenue generating event now. So it used to be for years and years and years, they never enforced it, but now the counties are enforcing it because it's a way to generate revenue. So I can tell you exactly who has to have an occupational license and who does not. To some, yes, in most cases. Your receptionist doesn't, your text. No, she wouldn't qualify because that's, her job duties are more involved in the greeting and the meeting. But your finance people, your, certainly some of your commission sales people, your comptroller, if you have a controller. There are certain people that are supposed to have occupational licenses in order to do their jobs in various counties, in all counties in Florida. I'm sorry? I don't know what the fine is because it's specific to county. The fee is only like $15 per year. I'm sorry? Oh, Rob, do you know? No, Rob leaves all the technical stuff to me. He's the genius. So, but this is where I am and where to find me. Like I said, I do things for free. Yes.
Question for you, but I think this is state law, if I remember correctly, so you may not know. In the state of Minnesota, my understanding is that if you release somebody at work, you fire them, you have to pay them within 24 hours of the final.
Yes.
Firing with the final check. If they quit, you can put on the next payroll.
Yes.
And then also, if they resign and you say they gave you a 2-week notice and you said, okay, you can leave now, you still have to pay them for that 2-week notice.
You do. Minnesota is very particular like that.
Can they give a month notice, or is it limited to 2 weeks?
You know, unless you have a contract or your employee handbook says you must give 30 days notice, the statute defaults to 2 weeks unless you have agreed to something else. I usually, for your business, cut it down to a week. What do you care?
So you can write that up on your employment.
Absolutely. You can contract around that statute in the state of Minnesota. It defaults to 2 weeks if you don't.
So you could technically say that if you quit your history and you get nothing.
Correct. But you have to, and they have to sign off on it, and you have to be sure, you know, that if you resign your position, you will get your last paycheck within X period of time, but you will not be paid for any notice period. It has to be very explicit. Yes, sir. Did you have a question, Pink?
Yeah, I do. You have managers that are paid on salary based on your sales, and then you require them to do extra training, they say, well, I'm not being paid for that. How do you enforce that with your managers? Is that
Well, because, yeah, it is a condition of employment because most of your managers are clearly making more than minimum wage. So as long as the training does not make them go below minimum wage for the hours worked, you can make it a condition of employment. I hear that all the time, you know, I don't get paid for that, but here's the deal, when you're a manager, don't they get a percentage, do they get a percentage of the revenue of the whole dealership? That's the way it rolls. You've got certain requirements to do. If you're generating revenue, if you're generating income off of the assistance of others, part of your job duties are to help train those others.
So, for example, you require a manager to get their training, they say, well, I want to do it in a couple of times, there isn't enough time to do it at home, this is why I'm not paid for that.
Is the training mandatory for compliance issues?
That's the field principal is trying to enforce.
Yeah. You know, I would not let them do the training at home. I would say you're just going to have to carve out the time and do it at work so that it's all part of the same thing. Because what you don't want to get into a trap of is having them say, well, I did this training for 26 hours, so you owe me X number, and I've fallen below the minimum wage, so you owe me X number of dollars, and you have no way to track that. So it's always my preference that people don't do training at home. I know that that's not always feasible, but I have to tell you, I think that it's a better practice.
Most dealerships have a social network policy.
Oh, yeah. Every employer. I don't care who you are. You better have one. Now, the federal government says now that you can't ask for people's passwords on Facebook and everything. You can't require that they give you their passwords. You're entitled to see anything that's public, but you better have a policy. And I always say that the most important policy you have is not the confidentiality, although that's important. The most important policy you have is a non-disparagement agreement that says that they can't go home and on their private Facebook page talk about how terrible their boss is and how terrible their employer is and how, you know, it's so-and-so sleeping with so-and-so, because I guarantee you that stuff is out there. The stuff I see is amazing. But you should have a non-disparagement agreement that is part of your employee handbook that says that they will not post adverse information about, not just confidential information, you already got that covered. That's your finance stuff, confidential client information, I know you guys have already got that covered. I'm talking about the ability to sit on Twitter and in 140 characters blow you out of the water as an employer and wreck your reputation. Yes, sir.
To follow up on the question I just asked, as far on, for instance, if you got a manager, he gets a percentage of the sales, he gives notice on the first of the month for the 15th of that, he's leaving on the 15th of the month. How would you break down, as far as what you're gonna end up paying him, if you told him to leave right away?
You have to estimate, yeah, there's a certain estimation to it. You are allowed to estimate on the commission that would be earned for that period of time, is that what you're asking? So you can pretty much go ahead, I would take the average of the 3 months before that, yeah. Correct, you have to estimate, and then the problem is the recovery if you're over, because you'll never get it back. Yeah, so do your best estimation, but that's what Minnesota requires. You're the only state that requires that. Besides, I think New Hampshire requires that too. Okay, my time is pretty much up, but I am here. I'm going to do the next session as well, so please feel free to stay. Again, please contact me. This is what I do. You may have figured out that I'm really a geek, and I really do love this stuff. And there was a nice lady over here who had her hand up that I didn't get to answer her question, but I'm going to track her down and make sure that I answer it for her. But please feel free to contact me. This is what I do, and it's been an absolute pleasure. Thank you for coming to my presentation today. Thank you.